I'll be dealing with two things today, dying declaration and last seen theory. Before I begin, you should understand what is a dying declaration. And so dying declaration and last seen theory both are part of what we call as circumstantial evidence or indirect evidence. There can also be direct evidence in which there are witnesses present, and that's called direct evidence. Dying declaration, what is dying declaration, first of all? A dying declaration is a statement given by a person who is dying about facts that have led to his death, or, transactions that has led to his death. Let's say if a person is shot on the street and he's bleeding on the street, someone is passing by on that street and sees that person. That person says that, oh, so and so person has shot me, and that statement that person who's dying gives about cause of thing which has caused his death, the name of the person who has caused his death, these facts are relevant facts, and these facts are called what is called as a dying declaration. What is I'll just deal with one more minute with direct evidence, indirect evidence, and hearsay evidence. Direct evidence is where there are witnesses available who have witnessed the offense or the incident, and they are directly available. This is direct evidence. When there are no witnesses available, if something happens in a abandoned warehouse or on a empty street where there are no witnesses available, the victim only is the person available, and he gives some statement, that will be dying declaration. But that will also be circumstantial evidence, because that person who has given the statement is no more. He will not be present in the court at the time of cross examination. So that statement becomes circumstantial or indirect evidence. Now, what is hearsay evidence? Hearsay evidence is when a person does not personally witness a incident or an offense, but hears it from someone else. Let's say I'm walking on the street, I hear there's an accident or someone, there's a hit and run case. Someone, the truck driver hit a scooty, a person riding a two-wheeler and has run away. Now that incident comes to my knowledge via some third person. Now, if I go and give the evidence in court, that will not be admissible, because that is hearsay evidence. Because I have not personally seen who was driving the truck, when the truck hit, where the truck hit the two-wheeler. So all of these are only hearsay. I've heard this from some other person who himself may not be available for cross-examination. So my statement, if I go and give it in the court, say that no, no, I've heard that this truck driver bearing number so and so of the truck hit the scooty, hit the two-wheeler, as I've heard about it. This will not be taken into consideration because this is hearsay evidence. Now, dying declaration is also an exception to the hearsay evidence. Why is it an exception to the hearsay evidence, or why is the court, accepting dying declaration? Because the person who has given the declaration is no more. He is not available. He cannot be brought to the court and examined and cross-examined. So the next best thing to do is to rely upon the statement that person gave at the time when he was dying, and to base a conviction or acquittal based on that declaration. Now, dying declaration is an exception, and it is also accepted because of the based on the maxim Nemo moriturus pessemutur mentare, which means a man will not meet his maker with a lie in his mouth. As we say, marta hua aadmi jhoot nahi bolta. When a person is dying, all his ulterior motives to make sure that someone who is not the actual offender is convicted, that is all gone. When you're on a deathbed, you want to speak the truth, because a person who's dying, he does not want to meet his maker with a lie in his mouth. That's the idea. So that is the reason why dying declaration, though it is an hearsay evidence, it is accepted by courts. And also because what happens in a lot of cases, if let's say someone is killed in a uh, warehouse which is abandoned, right? And if a police is taking a roundup and patrolling, and police officer comes across the person who's dying. Now, if that in the meantime that person is taken to the hospital, that person dies. if the person, whatever statement he makes to the police officer while he was in the warehouse and he's dying, is not accepted by the courts, the court may not have any other evidence to convict the accused person because it has happened in an abandoned warehouse. So a person should not walk scot free. Accused person should not be able to commit an offense and walk scot free. That is the reason why a dying declaration is accepted by the courts. Now, what are the requirements or requisites of a valid dying declaration? There are a few requisites of a dying declaration which should be kept in mind while a dying declaration is being made. The first is, obviously the victim should die and he should not be in a position to provide evidence. So if a person is making a declaration but that person survives, then that dying declaration has no value. Because that person is alive, that person can go before the court and say, look here, this is the person who has shot me, I'm giving the evidence, he can be cross examined, and all that can happen. So then in that case, the person is alive, that dying declaration has no value, and he will have to be present in the court, give his examination in chief, be cross examined, and then the court will decide on the fate of that case. So first thing is that person should be no more. The second thing is that the dying declaration should deal with facts that lead to the death of victim. So that this does not mean that a person who's dying, anything he'll say that will be accepted as truth. So if, let's say, I'm dying and if I say that this person owes me 7 crore, that will not be taken as dying declaration, and that will not help in any court of law. Dying declaration helps only so far as situations and facts that have led to my death, that can only be considered as dying declaration and be relied upon by the court. Third is that the deceased, when the victim, when he was making the statement, he should be in a fit state of mind. That is, it should be made sure that he's not tutored or prompt, or he's not hallucinating in that sense. What happens is sometimes family members, let's say, if I and my neighbor has an issue, if my neighbor kills someone, I'll say that my neighbor did it just to implicate him in that crime, so that he's taught a lesson. That should not happen. So what is important is that the dying declaration should be free, it should be voluntary, and it should not be tutored or prompted by anybody. In one case, what has happened was the statement was recorded, the dying declaration was recorded by the investigating officer, where he said that X person has committed the offense, and he has stabbed me or and shot me or whatever. But later on, after the statement was recorded, the person said to the investigating officer, "Oh, no, 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 that person has not in fact done it. This statement I gave only based on whatever prompt and whatever tutoring my father and my brother gave me." And when this fact was brought to the notice of the court by the investigating officer himself, the court said, no, we cannot rely upon this dying declaration because this is tutored, and that was not relied upon. So the next thing is the dying declaration, if possible, should bear the signature or thumb impression of the person who is dying. But obviously, this cannot be possible in all situations. Someone has 100% burn injuries. That person may not be in a position to put a thumb impression on a dying declaration, in which case the court will accept the dying declaration, even though if it doesn't have a thumb impression or a signature. The next thing is there is as such no prescribed format or any particular way a dying declaration can be made. But as far as possible, if possible, the dying declaration should be in a question and answer format. It should not be something where just the person is saying, and you are writing it out. If possible, if it's done by executive magistrate, it should be as far as possible in a question answer manner. So these are some of the requisites which are required. I'll deal with them in a certain detail right now. So this maxim, nemo morituris pessemutur mentare, which means that a man will not meet his maker with a lie in his mouth. This was dealt by the Supreme Court in Sham Shankar Kankaria versus State of Maharashtra. 2006 13 SCC 287. I'll share the PDF later with the PTIM. Now, I'll just read section 32 subclause 1 of the Indian Evidence Act which deals with dying declaration and why they can be accepted by courts. Cases in which statement of relevant fact by person who is dead or cannot be found, etc., is relevant. Statements written or verbal of relevant facts made by a person who is dead or who cannot be found or who has been incapable of giving evidence or whose attendance cannot be procured without an amount of delay or expense, which under the circumstances of the case appears to the court unreasonable, are themselves relevant facts in the following cases. Subclause 1, when it relates to cause of death. So a person is unable to come to court because he's dead, or and that relates to cause of his death. That is relevant in subclause 1. When the statement is made by a person as to cause of his death or as to any of the circumstances of transaction which resulted in his death, in case in which the cause of person's death comes into question, such statements are relevant whether the person who made them was or was not at the time when they were made under the expectation of death, and whatever may be the nature of proceeding in which the cause of his death comes into question. So a person makes a statement about what caused his death or transactions that led to his death. These are relevant and this will be admitted by court. Now, in this case, what has happened was a dying declaration was recorded by a doctor. But what has happened was that doctor only said that the victim was conscious. He did not say that the victim was in a fit state of mind when the declaration was made. So the defense that was taken was this only he was only conscious. But conscious is different from being in a fit state of mind, and this cannot be relied upon. Supreme Court said that the prosecution to prove the dying declaration as being genuine, true, and free from all doubts, and it was recorded when the injured was in a fit state of mind. The certificate only says patient was conscious at the time of recording. In medical science, two stages, namely being conscious and being in a fit state of mind, are distinct and not synonymous. They're not synonymous. Being you may be conscious, but you may not be in a fit state of mind. And they gave the benefit of doubt to the accused person. Now, this judgment, I personally feel that there is something which I think personally, yeah, this is correct, because some person may be conscious, he may be under drug, so he may not be able to, in a fit state of mind, to make a declaration. But this was overruled by this Constitution bench of the Supreme Court in Lakshman versus State of Maharashtra, 2002 6 SCC 710, in which the Supreme Court said, no, it's not necessary that the dying declaration must specifically state that the person was in a fit state of mind. If it says that, he was conscious also, but from the statement of doctor, we have realized that he was in a fit state of mind, that can be relied upon. Yeah, so that Constitution bench, the court said, where it is proved by the testimony of the magistrate that the declarant can be acted upon, provided the court ultimately holds the same to be voluntary and truthful. So, if the court holds that the statement was voluntary and truthful, even though it's not specifically stated that he was in a fit state of mind, that can be accepted. In the next case, the question before the court was, here a woman had died. The sister of the woman, they have filed a case under 498A, harassment by the husband and family members. What the sister was relying upon was conversations with her sister. She said, I had phone conversations with my sister where she said that her husband abused her husband tortured her. So the question before court was whether this will amount to dying declaration. Court said this is not dying declaration because this is not connected to her death. This is not, immediately before her death, she did not say this. This was long before, during normal conversation, she must have said, my husband, tortures me or something like that. But this will not fall within the purview of what we call dying declaration. And this cannot be used to convict the husband under 498 AIPC. So when the death is not related and the transactions are not related and there's no connection the court will not deal that as the circumstantial or the dying declaration and base a conviction on it. So in this case, the court said, whether there is a format, whether it will have to be in any particular format. This is State of MP versus Dal Singh, 2013 Criminal Law Journal, 2983. The law in the issue can be summarized to the effect that law does not provide who can record a dying declaration, nor is there any prescribed form, format, or procedure for the same. The person who records the dying declaration must be satisfied that the maker is in a fit state of mind and is capable of making a statement. Moreover, the requirements of a certificate provided by a doctor in respect of such state of disease is not essential in every case. So they said that the declaration from the doctor that he was in a fit state of mind is not required in every case. If the person who is recording the statement is satisfied that the person, that the victim is in a fit state of mind, that will be good enough. So who can take dying declaration? Is there a particular person only who can take dying declarations, or anyone can do it? The answer is anyone can do it, because if a person is dying on the street and if the police officer is not available and he's not taken to the hospital, or on the way he's being taken to the hospital and he succumbs to his injury, then there may not be anyone else available to record a statement. So whoever is taking him to the hospital, they may be random strangers, and if he says something, ki, am I enemy X person? He has stabbed me and I've has caused these injuries on me, on my body. And while he was being taken to the hospital, he succumbs to his injury. So that statement the person gives to the strangers who are taking him to the hospital will amount to a dying declaration. So dying declaration can be oral, that can be written, that can be by a stranger, that can be by a police officer, that can be by a doctor or by a executive magistrate. Now, what is the weightage of a dying declaration? A dying declaration corroboration, if is not there, also based on just a dying declaration, court has convicted persons. If there are, let's say, multiple dying declarations, then the law is different on that. Court usually tries to, rely on the first dying declaration, it being in the first in time available. What happens if a police officer takes down the dying declaration? A police officer can obviously take a dying declaration, but if time permits, if the victim is not died, and he's like in the hospital and he's hospitalized, and if it's possible to get an executive magistrate to record a dying declaration, the police officer must get the executive magistrate and make sure that the executive magistrate takes down the dying declaration. Because what happens is, courts have relied upon the dying declaration to convict persons, but courts are a little bit reluctant to rely on the dying declaration by a police officer, because police officer or investigating officer in that sense are not more interested in solving the crime. They are more interested in getting a medal, or just getting done with the matter. So courts are a bit reluctant to rely just dying declaration recorded by the police officer. If it is possible, then the dying declaration should be recorded by an independent person. That independent person may be a doctor or a executive magistrate. What happens if in certain circumstances, like the example I gave, a person is shot in a abandoned warehouse and he's dying there, and a police patrolling the area comes across that person, and while he's being taken to the hospital, he succumbs to his injury, then the police officer may be the only witness available. In that case, the court will not throw away the evidence of the police officer and say that no, a police officer has taken this dying declaration and we cannot rely upon it. So the point is, there is no certain format. All depends upon facts and circumstances of each case. In a case, there may not be time to take him to the hospital. He may succumb to his injuries on his way. So in that case, a police officer may record it or a stranger may record it. But of course, if a stranger records a dying declaration, he may only hear what the victim is saying while he's being taken to the hospital. He may not write it down. So the strength of that dying declaration is slightly weaker because, orally someone said something, you were rushing to the hospital, you may not remember or recollect it word to word what the deceased said. So that is on a lower side. If possible, a written dying declaration by a doctor or an executive magistrate. By executive magistrate, if it's there, it's the best evidence possible. And conviction can be based on sole dying declaration if there is no corroboration. What is important is that the court must feel that yes, I can rely upon this witness to convict this person. That is all that is required. If that is there, the court will rely upon this and convict the person. So in this case, there were two dying declarations, one before the magistrate and one before IO. There were contradictions in both of them, and so the plurality of thing dying declaration. So what court said was, we cannot rely upon this. There is a difference between what the magistrate says, what the IO says, and they have given the benefit of doubt to the accused. This is State of Maharashtra versus Sanjay Rajhans, 2004 13 SCC 314. Two dying declarations were there. One were before the executive magistrate, another before IO. There were contradictions coupled with high degree of improbability of the manner the occurrence as depicted by the prosecution case leaves little weight on these dying declaration. It is not the plurality of the dying declaration that adds weight to the prosecution case, but their qualitative worth is what matters. It has been repeatedly pointed out that dying declaration should be of such nature as to inspire full confidence of the court in its truthfulness and correctness. So in this case, the plurality happens. There are multiple dying declaration. In one dying declaration, something else is said. In other dying declaration, something else is said. The court gave the benefit of doubt to the accused. What happens is in criminal law, it is not the amount of witnesses we have, but it is always the quality of witness we have, which the courts rely on. There may be 100 witnesses, but the court may eventually acquit the person because none of the witnesses inspire the court's confidence that, the court is free in their mind to say that, yes, this person is guilty and we are sentencing him to imprisonment for life or death punishment. Point remains that always court sees is not the number of witnesses, but the quality of witness. A witness who will withstand cross examination, even if there is only one witness, the court will relying upon that evidence of that sole witness convict the person. That is the law in criminal matters. That even in if one is available, if its quality is good, it's good enough. It's not the quantity, it's the always the quality in criminal law. And of course, if the dying declaration is a result of tutoring and it's not free from prompting, then it cannot be relied upon, and the court will obviously give the benefit of doubt to the accused person. This was held in the Constitution Bench of Supreme Court in Mohan Lal versus State of Haryana, 2007 9 SCC 151. In this case, what court said that the maker is at the point of death, and all his intention to lie and all that is gone away, and whatever he'll say is he'll usually say the truth. Ravi Kumar versus State of Tamil Nadu, AIR 2006 SC 1448. Equivalent citation is 2006 9 SCC 240. Maker is at a point of death, and when every motive to falsehood is silenced and mind induced by most powerful consideration to speak the truth. What happens is if someone is dying, you know, the person who's dying will make sure that the actual culprit who has done the offense, who has stabbed him or who has shot him, should be punished. So he will not lie. He will try to make sure that the real culprit is caught and is convicted. So what happens if, let's say, a person makes a dying declaration, but he does not immediately die? He dies after 5 days or 25 days. Can that be relied upon? Court said yes. Courts have said yes, that does not matter how much time he has been in the hospital, maybe he was in the ICU or whatever. But if a person is making a statement, he has died, eventually he has died, and that statement relates to his death, cause of his death, or transactions that leads to his death, and that can always be relied upon, even if there's a gap of 5 days or 25 days. Because if a person is struggling in a hospital for 25 days, more reason to believe that the person, when he made the dying declaration, he was in a fit state of mind. This citation is Maniben Maharia versus State of Gujarat, 2007, 10 SCC 362. A dying declaration does not cease to be one just because death took place 25 days after the incident. In this case, 25 days after the incident, the accused succumbed to the injuries. Court said no matter what happens, he has eventually died. He has made this statement, will rely upon it, and they relied upon it. So let's say if it's recorded by a doctor, is it necessary that the doctor who's treating the patient should be the doctor who has given the declaration that yes, this person, this victim was in a fit state of mind? Court has said no. As long as a qualified doctor says that yes, this person is in a fit state of mind, this doctor is an independent person. If I am a doctor and someone comes to my hospital and he wants a statement about his fitness, about his state of mind, I will give it. I have no issues. Whatever happens eventually, whom that person says that is the accused and who gets convicted, is none of my business. I have the duty of being a doctor. I am qualified. I have no issues against, I have no personal axe to grind against the accused person. So court said that no matter if I'm not even the treating doctor, I'm not treating the accused, treating the victim. But since I'm qualified professional and I have nothing against the accused person, my statement that the victim was in a fit state of mind will carry weight, and that will can be relied upon. This case is Shanti versus State of Haryana, 2005, 12 SCC 287. Not necessary that only a treating doctor must certify fitness for making statement. No material to show that the doctor was interested in outcome. No reason to doubt certificate issued by a qualified doctor. What said that this is an independent person, there's no question of not relying upon his dying declaration. Of course, dying declaration can be acted upon even if there is no corroboration. This was held in AIR 1985 SC 416. Ever so many judgment on this that dying declaration does not need corroboration. Why is dying declaration, even being hearsay evidence and being an exception to the rule? Why is it admitted? This was before the Supreme Court, and the Supreme Court has in this matter said this. Ram Bihari Yadav versus State of Bihar, Criminal Appeal number 500 of 1990. Though dying declaration is an indirect evidence, being a species of hearsay evidence, yet it is an exception to the rule against admissibility of hearsay evidence. Generally, the dying declaration ought to be recorded in form of question answers. But if a dying declaration is not elaborate, but consists of only a few sentences and is in actual words of the maker, the mere fact that it is not in answers, question answer form cannot be a ground against its acceptability or reliability. So all these things that it should be in question answer form, there should be signature or thumb impression of these are all guidelines. If possible, as far as possible, these guidelines should be followed. But even if these, in certain matter, if it's not possible to follow these guidelines because the victim died soon after making the dying declaration, court will rely upon it and convict the person. And also, it's not necessary that the dying declaration should be very elaborate and very detailed as to every minute detail. That's not necessary. Even if a dying declaration is short, even if the accused, even the victim just says that the accused, so and so accused person has killed me, and he succumbs to his injury then and there, even that sentence, because it comes from the mouth of the person who is no more, that will carry so much weight that even that one sentence that can be treated as dying declaration and the person can be convicted. So there's no requirement that the dying declaration should be very detailed, or every particulars should be mentioned as such. Now, what happens if there are multiple dying declaration? Can happen that the person gave a dying declaration, then after some time he gave one more dying declaration, and after some time when one more dying declaration. If there are plurality of dying declaration, the general rule is the court tried to rely upon the first dying declaration. What happens is with time person may add some things up. He may make the story more better and better with time. So courts usually tend to try to rely on the dying declaration which is first in time. Of course, in some circumstances that it may be possible that when the first dying declaration was given, the accused was right there. So the victim could not have said that this is the person who has, burnt me or killed me or stabbed me in that sense. So that person may give a false dying declaration first, and later on, when the accused is not there, they give another dying declaration, and that dying declaration, being that accused is not there, court has relied upon that and convicted the person. Now, the next case law is dealing with that only. Kashmira Devi versus State of Uttarakhand, criminal appeal number 724 of 2019. In this, there was death after 4 years of marriage. Wife was harassed by the in-laws for dowry. There were three dying declarations. Two stating that the fire was caused, she died because of fire injuries, and there were three dying declarations. Two dying declarations when she made, she said that this fire was happened due to an accident. It was only an accident. But when the third dying declaration was made, she said that no, my in-laws are responsible. When the third dying declaration was made, it was made in the absence of her in-laws. First two were made when they were present. Court said that when the first two were made, the accused persons were right there. So the victim was maybe fearing for her life, lied about the dying declaration. But the third dying declaration, this is the declaration that inspires the confidence of the court, because the accused persons were not present when this declaration was made. So based on the third dying declaration, the court said that yes, they were convicted. What happens is also in some cases, the victim, if say there are 100% burn injuries, the victim may be heavily sedated, so that she does not feel the pain. Painkillers are given. She may not be in a fit state of mind, and she may give some dying declaration. In one case, what has happened was she gave a dying declaration and she died. But the dying declaration could not be used to convict the accused persons, because she was heavily, first of all, sedated, so that her burn injuries, the pain from those burn injuries could be lowered. And second of all, what happened was all the other witnesses who were there, they said, "Ki no, no, this person was not in a fit state of mind, and this is not actually what has happened." So there was a difference between what the dying declaration said and what the prosecution story said. So court said, no, in this case, we cannot rely upon the dying declaration. This person was heavily sedated, not in a fit state of mind. Prosecution story is different. So the court gave the benefit of doubt to the accused person. So this is more or less on what dying declarations are, is, and what the court has said or laid down in which the way the dying declaration should be. Now I'll deal with last seen theory. Dying declaration and last seen theory are both circumstantial evidence. There are no direct evidence available, so court relies upon circumstances around the death of the person to convict a person, and these are called circumstantial or indirect evidence. So, last seen theory. What is last seen theory? Let's say a accused person is taking a small child with him. Okay, some shopkeeper sees that, oh, this accused person is taking this child. That child dies, or rather, that child is killed for ransom. You know, so there is no evidence available. The body of the child is found, there is no other evidence available. Now what will happen? The investigating officer will investigate. He'll see where the accused, from where the accused has taken the victim. He'll try to find witnesses along the way. If certain shopkeeper says this, yes, I've seen this accused person with the little child who is dead, He comes forward and says, yes, I've seen this person. That is circumstantial evidence. That is last seen theory, because the victim or the deceased was last seen with the accused person. What is important is the time gap. If, let's say, accused and victim are seen together, and immediately 2 3 hours later that dead body of that child is found, the time gap is so small between the time when the shopkeeper saw the accused taking the victim and the death of the victim. The time gap is so small that the possibility of any other person coming and killing the small boy or the deceased is not possible. It's improbable. So in that case, based on the last seen theory, the courts convict accused persons. In this, what has happened was the body of the wife was found hanging in the house, and the prosecution story was that the husband has killed her. What the prosecution relied upon is 106 of the Evidence Act. Section 106 of the Evidence Act. I'll just read Section 106 for clarity of everybody. 106. Burden of proving fact, especially within knowledge. When any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. So what the prosecution said is, now the husband being the only person in the house other than the deceased, he must tell how the deceased died. And the prosecution said, taking benefit of Section 106 of the Evidence Act, we have done our job. It is for the husband to now show how he is not the accused person. The court said, no, 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 this is not how it works. The prosecution first has to establish the case beyond a reasonable doubt. Then the presumption under 106 kicks in. And then it is for the husband to show how he is not the accused person. Because if a crime is committed behind closed doors, usually it is for the person who is behind those closed doors to explain how the murder has happened or the crime has been committed. But in this case, the court said, no, no, this is for the prosecution first to prove. At least prosecution must do their basic job of prima facie at least prove a case. Then the presumption under 106 of Indian Evidence Act will kick in, and then the husband will have to explain. How can you prosecution simpliciter say, yeah, just because he's the husband, he has to explain it? We have done our job. No. Court, this is in Shivaji Chintappa Patil versus State of Maharashtra. Criminal Appeal number 1348 of 2013. Death of wife by hanging. In this, there was by hanging. There was a concurrent conviction by the trial court as well as the High Court. The matter traveled to the Supreme Court in appeal. And this was based upon the last seen theory, saying that, being the companion of the woman of her wife, he has to say how she died. Companionship of deceased and the husband by itself does not mean the presumption of guilt is to be drawn. Presumption under Section 106 of the Indian Evidence Act does not absolve the prosecution of discharging its primary burden of proving the prosecution case beyond reasonable doubt. It is only when the prosecution has led evidence which, if believed, will sustain a conviction or which makes out a prima facie case that a question arises of considering facts of which the burden would lie on the accused. So the court said no, it is for the prosecution first to prima facie at least prove a case against the husband. Only then the accused will have to prove that yes, he is not the one who has committed, and this has happened because the wife has committed suicide or whatever. And in this case, the accused was acquitted. Usually, what happens is if there is a concurrent conviction, the Supreme Court is very reluctant to acquit a person, and usual rule is that when there are concurrent convictions, the highest court must be very reluctant to because the presumption of the innocence is gone because the lower courts have already found the accused guilty, and courts are very reluctant to give the benefit of doubt or grant acquittal to accused persons. But in case like this, courts are very taken a stand and said no, even if there is a concurrent conviction, the prosecution has failed to even discharge its primary object. How can we convict this person? And they've acquitted him. In this case, there was kidnapping and murder. So This is about kidnapping and murder of a small child, and 325 to CRPC is only directory and not mandatory. This is okay. This is not important. I'll just deal with the next one. Conviction under 364, that is kidnapping with intent to murder. Accused was a servant in the house. He was previously a servant in the house of the deceased person, of the yeah deceased person, and there were people who saw the victim with the accused, and there were two three witnesses who said that yes, we have seen the accused and the victim together, and the victim was a small boy, and the accused used to work in his house. So the when the victim went along with the accused, because he knew him, right? He knew him and he went along with him. Few people saw him that yes, this person is taking this small boy, and that person then called and asked for ransom. That money was not paid. He killed the little boy. So the little boy, when he was waiting outside his school, and when the accused came and picked him up, the other boy who was with the victim said that the victim went along with him without raising any issues, because the person who came to pick him, he knew him. The court said no, this person, he was working in his house previously. So obviously the kid did not make an issue out of this when the person came to pick him up. He went along with this. There are other witnesses who are available who have seen the victim and the accused together. And he made a call for this ransom call. So based on all this last scene theory, and the boy's bag was found with the accused person, based on all this, and also the statement of the little boy that the victim went along with the accused, this was all taken into consideration by the Supreme Court, and he was convicted finally in this matter. This is Sanjay Rajak versus State of Bihar, Criminal Appeal 1070 of 2017. Equivalent citation is 2019 SCC Online SC 895. This was conviction under 364, that is kidnapping with intent to murder. Accused worked as servant in the house earlier, so victim child went along with the accused person. The father of the victim received ransom calls. Accused was seen with the child of 5 6 years by liquor shop owner and a hotel owner. So he was seen with the victim by two witnesses. One was a liquor shop owner and one was a hotel owner. And the school bag of the child was recovered from the accused person. So based on all of this, even the body of the boy was not found. The court said conviction where the corpus delicto was found. Corpus delicto is that rule that in criminal law, it is not necessary that the body of the victim must be found in all cases. It may happen that it is thrown into a flowing river and the body gets carried away and body is never found. Just because the body is not found, we cannot say that yes, this person has not committed an offense or he cannot be tried for that. In this case, the body of the victim boy was not found, but based on the last scene theory and the recovery of his school bag, he was convicted. Now, what is the rule as such in circumstantial evidence, or why? What are the things the court sees in circumstantial evidence cases? This was in dealt by Supreme Court in Jawaharlal Das versus State of Orissa. So, in circumstantial evidence, there are circumstances which the prosecution says that this is the circumstance, this is the circumstance. The accused took the victim. This is one chain of circumstance. The accused was seen with the victim. This is another and that was seen by a owner of a liquor shop and a owner of a hotel. This is another chain. And the body was not found, but the bag of the victim was found, and bag was found in last seen theory. This is a chain. This chain of circumstantial evidence must be so tight that the only thing that the court must see is the chain is so strong that the only thing that comes out of is that the accused person is guilty and he should be convicted. If the chain breaks, then the circumstantial evidence is not enough to convict a person. What the Supreme Court had said in this, I'll just read. Jaharlal Das versus State of Orissa, 1991, 3 SCC 27. It is well settled that the circumstantial evidence, in order to sustain the conviction, must satisfy three conditions. The circumstances from which an inference is sought to be down must be cogently and firmly established. So, the circumstances, the chain of circumstances must be firmly and cogently established. Those circumstances should be of a definite tendency, unerringly pointing towards the guilt of the accused. So the circumstances should point towards only thing is guilt of the accused. It should not, there should not be any other hypothesis that can be possible. Oh no, this is also possible, this is also possible. It should only point out that the accused is the one who has committed the crime. And the third thing, the circumstances taken cumulatively should form a chain so complete that there is no escape from the conclusion that within all human probability, the crime was committed by the accused and none else. It should lead to that this is the person who has committed and no one else. And it should also be incapable of explanation of any other hypothesis than that of the guilt of the accused. At times, it can be the case of may be true. So the prosecution may put a story and say that this, the court may feel that this may be true, but this is not 100%. Court may not be sure. This court may must be true, may not be there. Maybe this is what the prosecution is saying may be true. This may be true. This sounds true. This sounds plausible. But that is different from must be true. That this is the only thing that comes out of it. That this person is the one who has committed the offense. At times, it can be the case of may be true, but there is a long mental distance between may be true and must be true. And the same divides the conjectures from sure conclusions. So, court may sometimes, based on conjectures and surmises, convict a person, but court says that no, if the prosecution relies upon circumstantial evidence, that the story of the prosecution must be true and not may be true. If it's may be true, then accused will be given the benefit of doubt and he will be acquitted. That's about last scene theory. I think I'll just take questions if there are any.
There's one question that dying declaration given to a police officer, does
Right.
that convert into a FIR?
It can obviously FIR. What is FIR? FIR is nothing but a first information about a cognizable offense. If a person is stabbed on the road, that is a cognizable offense. An attempt on his life has been made. Based on that statement, the investigation will have to start. So FIR is first information. The police gets the information that this person is dying. So based on that information, the police will register an FIR.
The next question is, does a suicide note constitute a dying declaration?
Suicide note, will it constitute to dying declaration? Yes. If suicide note has certain things there which says that if let's say someone is harassing someone, and that person has committed suicide, it of course it will not be a murder, but abetment to suicide, that statement of the deceased will can be used and that can be done. Yes,
Okay. The
abetment of
next.
suicide for only for that, not murder obviously, but abetment of suicide that can be relied upon.
Okay, so a suicide note will be admissible as a dying declaration only in cases of abatement to suicide.
Abetment to suicide, yes.
Now, the next question is that cross examination cannot happen for a statement made on dying declaration, but the
Hmm.
third party recording the dying declaration, will that party be cross examined? I think the
Third
person wants to ask,
party,
like the police officer, doctor, any
right?
person
Yes, yes,
recording the
yes.
dying declaration.
Whoever records the dying declaration will obviously be brought to court, will be cross-examined, questions will be asked. Because what happens if, let's say, a doctor is recording a dying declaration, this doctor may have some axe to grind against a particular accused person, or the doctor may be a family member of the deceased. Then he may require, register, make a dying declaration in that particular for thing, making sure that the accused person is convicted. Of course, so to test this dying declaration, the person who has recorded will be brought to court. He will be subjected to cross-examination. Yes, like any other evidence, he will be have to be brought to court and he'll have to be cross-examined. Whoever records it, be it executive magistrate, doctor, police officer, the person will be brought to court and he'll be cross-examined.
The next is a message, a WhatsApp message dropped to a friend,
Hmm.
stating the facts or leading to the death of the victim. Will that
Yes.
be considered a dank declaration?
Yes, if the person is dying and he sends a message, yes, that will amount to dying declaration. Yes, that is
So,
even more good because that is in the words of the deceased person and it's written. So that's very good information in that sense.
the next question is, what about the statements? Before completing the statements, the witness or the victim dies. So, will that be constituted a dank declaration, or it will not be admissible?
Depends. Like let's say if the victim says that X person killed me and he's giving the details and he dies, then of course he has given the detail who has killed him. So that will can be relied upon to convict him, even if the details are not available. But if the person is giving details, he is not informed who the accused person is and he dies, then there's no point to that dying declaration that cannot be relied upon because we don't even know who the accused person is. The victim did not even tell who the accused person was. So in that case, that dying declaration has no weightage in that sense.
Ashish, any tips for participants? They will be appearing. There are many participants from the final year, so they will be. They
Right.
have evidence as a subject. Any tips for
Right.
them? How do they approach the subject? Because it's a very heavy subject.
I think this is what has worked for me. So I'll tell you, I have always tried to understand things with easy examples, and that has helped me remember things. So I think you should always, if when you're reading in anything, any section in Evidence Act, look at the illustrations. Those illustrations are very helpful. They give small examples and they really clarify the situation. So always try to do that. If possible, if you have time, look at case laws, how courts have dealt with it. I mean, obviously, when we are in college, it's not so much possible to do. But if you're interning and you have some doubts, you can obviously ask your seniors. They can easily clarify things for you.
Okay,
But
Ashish.
more or less, illustrations helps. Thank you so much, Malvika, for having me here.